Hi, everyone. My name is Richard Robinette. I'm an attorney with Crowdfunding Lawyers. We are a boutique law firm that focuses on private securities offerings, basically helping people with small businesses raise money from investors safely and legally. We provide all the legal documents you need to comply with securities regulations and just kind of guide you and hold your hand through along the way, so that you can have a successful capital raise and go out and conquer the world. So that's what we do. Today, I'm going to be talking about limited liability companies. Practically every transaction we do here at the firm involves one or more, usually more, limited liability companies that we set up in order to provide you some asset protection in the course of your business, because in business, things sometimes go wrong. People sometimes get upset. Lawsuits get thrown around, and we want to make sure that those lawsuits, as much of a pain in the butt they might be, don't absolutely destroy your life. So that's what we're here to talk about. Let's get right into it. I'm going to start with our mandatory disclaimer to protect ourselves. In a nutshell, this is an educational presentation. It's not meant to be all-encompassing. It's not meant to give you everything under the sun. And this is not an attorney-client type of relationship we're creating here. I want to talk generally about the subject so that you can be educated and decide whether you need to speak with counsel for more info for all the things you're doing. Here we go. All right. So you want to start a business, and there are tons and tons of different ways you can go about starting a business. We live in a relatively free country, which means anybody can go out and start a business today. I started my first business when I was 11 years old. I had a lawnmower and went and knocked on doors and cut grass and collected money, and that was my business. What I was doing, or what I created when I did that, was called a sole proprietorship. And sole proprietorship is just a person going out and doing business. Congratulations, you're in business. Sole proprietorship involves a single person. You don't even have to have a name. You can use your own name for your business, or you can go get an assumed name. A DBA. It's just usually a simple form you file with your county or with your state. It says my business is now called. Mine was called Affordable Neighborhood Lawn Mowing, because I'm super original like that. And so that was my DBA that I used when I knocked on doors and cut grass. A problem with being a sole proprietor is there's no limit to your liability. So if I ran my lawnmower into my customer's Bentley, there weren't any Bentleys in my neighborhood, but if I ran over his prized Chihuahua or something and created some kind of damages that my customer could collect from me, if he were to sue me, he can not only go after the assets of the business itself, but could also go after all my personal assets. And being 11 years old, my assets involve video games and not much else. But there was no limit to what stuff of mine could be taken by this judgment creditor were I to create a problem. So sole proprietorship is not a great, it's an easy way, but not a great way to operate your business. Similar to that is a partnership. And a partnership is basically just like a sole proprietorship, except that there's more than one person. So we have two or more people working together. Again, you could have an assumed name, so you could go out and get a DBA for your partnership. There's no actual business entity filing you have to do for a partnership. And if sole proprietorship wasn't bad enough, in a partnership, you're not only liable for all the crap you do, you're also liable for all the crap your partner or partners do. So in a sense, from a liability standpoint, it's even worse than going out on your own as a sole proprietor. And another problem with partnerships is sometimes they're created by accident. I didn't even intend to start a partnership. I didn't intend on being liable for my partner's actions, but because my partner and I just started doing business together, sometimes the government will deem us to have formed a partnership and hold us accountable accordingly. And so obviously the two big problems with these two entity structures is a lawsuit. Lawsuits will completely not only wreck the business, but could wreck your personal life. So really, when I say you want to start a business, kind of a more accurate statement would be, so you want to limit your liability when you start a business. And throughout the ages, there have been ways of doing this. One of the simplest is called a limited partnership. And the concept of a limited partnership, not by this name, of course, but the idea actually dates back all the way to the Roman Republic in 300 BC. There were forms of limited partnerships. So limited partnership, it is still a partnership. So you have to have 2 or more people. And there's 2 roles in a limited partnership, a limited partner and a general partner. So you got to have at least one of each. So limited partner. So on one hand, you have limited partners. On the other hand, you have general partners, 1 or more of each of those. Limited partners have little or no control over the business. A lot of times they're just the person that invests money, for instance. And they also have limited liability. And by limited liability, I mean that the liabilities of the partnership, of the entity, don't overflow to the individual limited partners. So if I'm a limited partner, my exposure is no more than the amount that I've invested into the partnership and maybe any money that money has earned. General partners, on the other hand, are the same as partners in a regular partnership. So they have control over the entity, over the business, but they also have unlimited liability, and that's joint and several liability. So the drawback of a regular partnership is also the drawback to being a general partner of a limited partnership. Okay, another common one that's been around for ages is a corporation. The earliest corporations, again, the Romans, the Roman Empire, around the time of Julius Caesar, had corpuses, which were very similar to our corporations today. The modern form of corporation has been around since the late 1800s and hasn't changed a whole lot since that time. And corporations are just organizations of 1 or more people. They are managed by officers who are appointed by a board of directors, and a board of directors is elected by the shareholders or the owners of the corporation. And corporations provide limited liability for those shareholders. So again, liability is limited only to what someone has put into the corporation. So the liability of the corporation for its acts doesn't flow over into its owners, onto its owners. There are exceptions. There is what's called piercing the veil. So if we do some funny business or we don't maintain the corporation properly, that could create liability for shareholders. But the idea is that corporation, the liability is limited for all of the owners, and that it's supposed to encourage them to maybe take business risks they otherwise wouldn't take. And theory is everyone would be better off if those risks are taken and those businesses are started. So drawbacks I kind of pointed out already. Limited partnerships, unlimited liability for general partners. So somebody has got to be there to take it in the shorts when things go wrong, and that sucks. There's ways of limiting that. Of course, we could take a limited liability company, for instance, that we're going to talk about in a second, and make a limited liability company the general partner, and use the LLC's liability protection to protect that general partner. And corporations, better, in my opinion, than limited partnerships from a liability standpoint, but problems with them is it's very inflexible structure. For instance, you have to have a board of directors. If you elect to be an S Corp, which you might do to avoid double taxation, you can only have 1 class of stock within your corporation. You're restricted on the number of shareholders you have. If you want to have multiple classes of stock, or if you want to have more than 100 shareholders, then you need to be a C corporation. Problem with C corporation is double taxation. So, there's a lot of difficulties with running a corporation, and there's also corporate formalities. We got to have meetings with a quorum and minutes, and and all these kinds of things that are just a little bit of a pain in the ass, especially for maybe smaller businesses that don't have the resources to really focus on that stuff. I want to focus on serving my customers and making money, not, you know, having meetings and taking notes all the time. So that's kind of where we were stuck for many, many, many years. And then things changed. 1977, and what a great year 1977 was, or must have been. I wasn't born yet. I came around just a little bit later. But 1977 gave us Star Wars, the Atari 2600, Saturday Night Fever, Meatloaf's classic Bat Out of Hell, the Voyager 1 probe, and the great state of Wyoming, who blessed us with the very first LLC Act. The invention of limited liability companies started right there. It's still one of the best states to form LLCs in. And this changed everything. So within 20 years, every state in the United States had LLCs, and even some territories in foreign countries have LLCs now. All right, so what's so great about LLCs? For one, they provide limited liability for all the stakeholders. So unlike the limited partnership, there's no general partner. There's nobody that has to have to basically be the guarantor of everything. There's nobody that has full exposure. Everyone gets their liability limited. They're super flexible in how you structure them. Do you want a board of directors? You can have a board of directors. Do you not want one? You don't have to have one. There's all kinds of ways you can structure your LLC. It's very free, very Wild West. Flexible tax elections we'll talk about in a little bit, and far fewer formalities. We don't necessarily have to have annual meetings with minutes, and we don't necessarily even have to have voting among our owners. We can make our own rules, and that's a really great thing. So let's talk just a little bit about some of the nitty-gritty of flexibility of LLCs. LLCs can be member managed or they can be manager managed. So member managed basically means all the owners also make all the business decisions. We have an LLC and there are managing members. Those managing members exercise control. So very similar to a partnership where everyone's got their stake, everyone's got their vote, and we just all do business together under this umbrella of an LLC. Alternatively, we could be manager managed. Have an LLC and have a manager, one or more managers on one hand and one or more members on the other hand. And we let the managers have all the control and do all the work. And they might receive fees or some kind of compensation for doing that. This is the structure that we use most often in syndications and investment funds and things that we do in our office. And this is kind of like where, you know, a corporation with maybe like executive officers that are making decisions, and then shareholders who are just investing money and sitting there like houseplants. So you can set this up either way or come up with your own way of running things for an LLC. Okay, profit sharing and voting rights don't have to be split up according to the investments, according to ownership percentages. So I could have an LLC and my LLC maybe has managers and maybe we have two classes of members. Class A and Class B, the names don't matter. We can call them whatever we want, but they're just categories of owners that we create. And let's say, for instance, we have this LLC manager doesn't invest any money in it. He just is elected to run things. And let's say our Class A members and our Class B members have contributed 50-50, half of the capital for the LLC. And the LLC runs off and does whatever business it does, buys property, and opens a store, whatever. But the members and the managers can all agree that, well, we're not going to just split the profits 50-50 between Class A and Class B. We're gonna do things different, and maybe to incentivize one class or another. Incentivize, if you invest more than $100,000, you get to be Class B and you get a bigger percent of the profits. Or if you invest earlier, you get to be in a different class and get different treatment. So maybe we give our manager 20% of the profits and we give our Class A members 35% of the profits, and Class B members 45% of the profits. I think that adds up to 100%, but I'm not very good at math. So you get the idea. You don't have to have that match your direct ownership of the entity. You can change the rules. You can incentivize people in different ways by splitting these kinds of things up. All right. Most provisions of the state LLC acts can, and in my opinion, should be superseded by a company agreement. Now, company agreement, also called an operating agreement, is just an agreement among the members and the manager, if there's a manager, on how the LLC is going to run. What are the rules? What are the things it has to do? Similar to bylaws for a corporation, partnership agreement for a partnership. If you don't have a company agreement, the state has provided one for you, and it probably stinks. So the LLC Act in your state is going to have a basic outline of rules for how an LLC should run. Almost all of those rules are going to be waivable. So you can write your company agreement and say, no, 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 we don't like the way the state wants us to do it with their one size fits all idea. We're going to do it this other way. So you can supersede all those LLC Act rules for your own rules. And that's a really smart thing to do, because it's very unlikely that the state's default rules really fit how you want to do things. I was involved in and with an LLC several years ago, and there was a dispute going on, and the manager made a big mistake, and that was that they formed this LLC but never did a company agreement. So they were stuck using the state's rules. So here's what happened. We had this LLC. It had 3 members, and one of the members was also the manager. So this member, in addition to being a member or an owner, got to run the day-to-day operations and make the decisions on behalf of the LLC. And the manager also put in 60% of the money. He owned 60% of the interest in the company. And the other 2 members each put in 20%. And I represented these 2 members. These 2 members decided that their manager sucked, and he was not doing very well. He was not handling money right. He was creating all kinds of problems, and they just wanted him out. And how the heck do you vote a guy out when you've only got 40% of the units or 40% of the ownership of the company, and this guy over here is sitting on a majority? So they called up, what do we do? How do we get rid of this guy? And so I said, well, let me see your company agreement. Well, we don't have one. Okay. So I go and I look in the Texas Business Organizations Code that has all the rules for LLCs that don't have their own company agreements. And there's a section on removing the manager. And this says removing the manager can be removed with or without cause at a meeting of the members. So members can call a meeting, vote the guy out. Now, again, problem is that this guy's got 60% of the ownership, right? So how the heck are we going to win the vote? Well, you don't vote on ownership. In Texas, at least, and probably several other states, I didn't do a 50-state survey, but in Texas, at least, the default voting is by head count. It says each governing person, member, or committee member of a limited liability company has an equal vote at a meeting of the governing authority members committee is appropriate. So we have a meeting of the members. There's 3 members, and each member has an equal vote. So what happened? Well, 3 members, each one has a third of the voting. So these 2 members get to vote and kick the manager out. And that's exactly what happened. So if you're the manager, get a company agreement and write it in a way that protects you. Don't do what this guy did. All right. And then LLCs can elect to be taxed like other entity types. They're kind of chameleons as far as taxation goes. So there is no actual taxation of LLCs. The IRS doesn't recognize LLCs as LLCs. They recognizes them as another entity type that they elect to be. So LLCs can be disregarded entities, which means they're treated from a tax perspective like sole proprietorships, which means just the profits and everything just go on the individual's personal tax return. Now, in order to do this, you have to either be a single member LLC. So I'm the only owner of my LLC. I can elect to be disregarded. Or if you live in a community property state like Texas, husband and wife can be considered a single member and be a disregarded entity. LLCs, if they have multiple members, can elect to be taxed like a partnership. Now, partnerships are not taxed directly. The partnership will split up an allocation of its profits and losses to its partners and say, okay, well, you got 30% of the profits and you got 70% of the profits. You pay 30% of the tax burden and you pay 70% of the tax burden. And then that goes to their personal income tax statements. So LLCs can be taxed like that. And each member of the LLC is treated like a partner and gets their proportion, their share of the tax burden or tax benefit, as the case may be. LLCs can also choose to be taxed as C corporations, which I'm not an accountant and I don't understand these things very well, but there are certain situations in which being a C corporation has tax benefits, or an S corporation. So one of my own LLCs, I actually spoke to my CPA and he advised me to be taxed as an S corporation as a way of saving on payroll taxes. And so I did. All right. Moving on, as if that wasn't great enough, there's a fairly new idea that has been adopted in several places called a series LLC. So here's kind of the conceptually how this works or how this came about. So let's say you're an investor, just as an individual, you're a sole proprietor, and you buy a bunch of rental houses. And you also own several other assets. So maybe you have a big vacation house somewhere. You've got your car, you've got your bank accounts, you've got your personal effects, all this stuff that you own. And lo and behold, tenant slips and falls in house number 2. They sue you. All of your stuff, all of your assets, with maybe some exceptions. For instance, Texas protects your homestead. But for the most part, all the things you own are at risk for covering the damages in this lawsuit, assuming you lose. And that's not great. So what do? Well, you could put all the houses in an LLC, and then along comes the lawsuit. And since the lawsuit involves assets of the LLC, the only exposure is the other assets in the LLC. Okay, so this is a little bit better than what we had. My car is safe, my bank account's safe, assuming there's no piercing or anything, but I'm not going to get into that in this particular discussion. But I have asset protection for all my other stuff, and the only thing at risk are these other houses that are held in my LLC. All right, well, what if we just chopped it up more and said, well, let's just put each house in an LLC? And this works really well. I got a lawsuit on this, this particular house. It's the only asset of the LLC where the lawsuit's happening. So it's the only thing that's at risk. That's great. But you can probably see the problem as your business grows and grows. Now you have tons and tons of LLCs. Each of these might even have to have their own tax return every year, which is expensive. You have filing fees. Some states have annual filing fees, franchise taxes, and all kinds of other expenses. So having tons and tons and tons of LLC eventually becomes pretty difficult to manage. So what do? Well, what if we just put all these houses into one LLC, and then we could just like split it up and put some asset protection around each asset within one single LLC. This is called a series LLC. And each of these little cells that I created here are called series. So I might have an LLC, 4 houses, for example, and series 1, 2, 3, 4. I can have as many as I want. And someone slips and falls in the house owned by series number 2. And that's the only asset that's at risk. This is pretty cool. This gives you the benefit of having all those different LLCs without all the paperwork, without all the tax returns, without all the expense and the headache. This really simplifies things and gives you the same benefit. When I started working with my partner, Nate, who you're going to meet here in just a little bit, there were 11 states that had series LLCs. And now we're up to 20 states and the District of Columbia that offer series LLCs in one form or another. Now the statutes aren't all identical, but the concept is basically the same, where one LLC can provide additional divisions of asset protection underneath itself. So a couple things about series LLCs and the series underneath them, which makes them a little bit tricky, I guess, conceptually, is that individual series 1, 2, 3, 4 here, they're not entities. They're not business entities. They're not, with a few exceptions. I think Delaware has started doing this, but in general, they're not registered with the state. There's no filing to create a series. They only exist in your books, in the books of your LLC. And that means you as the owner, if you're going to do series, you need to document it very well, because each series has to exist as an independent business. And so its assets, including its cash in the bank, has to be segregated from all the other series. Otherwise, you're back in the situation where you just have a bunch of houses sitting inside one entity. Another issue is, if I'm a plaintiff and I'm going to sue you, and I'm like, I want access to all these assets, and you say, no, this is a series LLC, and all the only assets you can take are in this one series. I'm going to argue, well, he just created the series to avoid, paying me in this lawsuit, and you as the defendant, you're going to have to prove it up and show, no, really, I created this series years ago. I put only one house in it. Here's all my records of this. Here's all my books, very organized. And so, if everything's a mess and you can't definitively prove that you created these series and you kept everything separate, you're going to have a hard time when it comes to claiming that only these assets should be vulnerable to the lawsuit and all these others should be protected. Now, series are still pretty new. They're not in a majority of states yet. There's questions about them because they're not entities. What rights and obligations do they have? Because in some sense, they look like entities. They have asset protection like entities. It's unclear in some places still whether a series can enter a contract, whether they can sue or be sued, or whether you have to sue the parent. It's still a little bit nebulous. It hasn't percolated through the courts yet. We're starting to see some uniformity come along. There is a Uniform Series LLC Act that is been adopted in a handful of states, but not super widely yet. So there's a lot of attorneys that actually will just tell you, don't use series. They're not ripe yet. We don't know enough about them. It's risky. I'm not of that opinion. I like series, and I think that it, like most asset protection schemes, there's going to be a trade-off, and you're always trading asset protection for expense and headache. And so this probably sits right in between having just one big LLC that's just one big bucket holding your assets, and the more expensive, more headachy option of having LLC, 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 LLC. So it's probably not as good from an asset protection standpoint as having literally separate business entities formed. but it's certainly a lot better than just having everything all lumped together. So that's my song and dance on LLCs and series LLCs. I hope this has been helpful. I am going to bring on my partner and good friend, Nate Dodson. Drum roll, please.
Howdy, howdy.
What's up, Nate?
How you doing?
I'm awesome. I'm on top of the world. Little cotton mouth. I probably need to take sips of water while I'm speaking.
Well, you know what? I one topic that that I hadn't heard you talk about a little bit, but would love it if you could dive in a little bit. I don't know what other questions we have, but I'm always being asked, what state should we set up this LLC in?
What state should we set up the LLC in? That's one of those questions where the default lawyer answer of "it depends" comes out. Different states have different LLC regimes. Some are better than others. Some offer better protection than others. So and different expenses and things like that. You know, we live in the great state of Texas, free and independent Republic of Texas, which has pretty darn good LLC laws, pretty strong. So considerations when thinking about a state, one of them is what is the remedy for someone suing you personally and trying to collect their judgment from your LLC? And in most states, the only remedy that if I sue you and you have an LLC, the only thing I can do to the LLC is get what's called a charging order. And a charging order is an order from the court that tells the LLC, whenever you make distributions, whenever you pay your members, instead of paying the defendant, you pay me, the judgment creditor. In a handful of states, however, I think California is one of them, I, as the judgment creditor, could actually foreclose on your LLC interest and take the LLC ownership from you. And now I get to be the member of the LLC. And obviously we don't want that. So, you know, that if you're considering maybe, should I form in California or Texas, the Texas offers a clear advantage over California there. Another consideration is anonymity. So Texas, on your certificate of formation, when you form an LLC, you have to put the names of the managers or the controlling member, the managing members, on your certificate of formation with your addresses for all to see, and it's public record. If your business is in your house, you might not like that very much. I mean, you could use a PO box or something, but your name is still going to be there. Whereas if you form in Wyoming, for instance, or in Delaware, the certificate is completely silent on who owns it or who manages it. And the only person listed on the certificate is what's called the registered agent. Registered agent is just someone with an office in that state who sits there and waits to receive service of process if the LLC gets sued. And so I've got a Wyoming LLC. I have a registered agent. I pay $120 a year or something for them. And they've got an office and they've got someone sitting there that if I ever get sued or my LLC ever gets sued, they can march into that registered agent's office in Wyoming and deliver the lawsuit. So if anonymity is a concern, you could form in Wyoming. Now it's kind of tricky because if you have a Wyoming LLC and if you transact business in, say, Texas, you have to register as a foreign entity in Texas. And guess what? You have to disclose the managers. So now that anonymity has gone away. So it's one of those conversations you should have with your attorney. If you're looking to form an LLC, go through all the pros and cons of forming in different states.
I'd like to throw something out, you know, at the same time, and your attorney, being a wise attorney, should always basically say it depends until you get through the entire discussion. Maybe that makes sense.
I've actually got a t-shirt that says it depends.
I like it.
Show it to people.
And it is not for incontinency, I presume. It depends. All right. So one thing that I always thought was really interesting, and we do so much in Texas since we're primarily based here, I'm really surprised all the time to form an LLC in Texas. $300 filing fee.
Mhm.
To file as a foreign entity in Texas, $750.
Yep. And that's one of those considerations you're weighing when you're deciding where to form.
And, you know, sometimes people just don't want to do the foreign entity filing, don't want to disclose that information. What do you tell those people that don't really know or don't want to file?
I mean, you're taking a risk, right? If you transact business in a state where you're not allowed to transact business because you haven't done the proper filings, they may come knocking on your door, and then you could have fines and penalties. You could be barred from doing business in the state and all kinds of bad things.
I know at least around this state, one of the biggest penalties is actually you're not allowed to defend yourself in court if you haven't filed your entity with the state, which I think just sounds insane, but.
Or if you haven't filed your franchise tax filings. So for Texas, all you Texans, most of your LLCs aren't going to pay any tax as long as your revenues are under, I think it's 1.1 million or something. I haven't looked it up recently, but your revenues have to be really, really high before there's any tax. But there's a filing you have to do every year. It's due in May. And if you don't do that filing, they will take away your right to transact business. And so if your LLC gets sued, guess what? The LLC is not there anymore. And they get to sue you.
They sue you. Kind of an interesting thing that I had to go through a long time ago when I had a firm in Las Vegas. We would organize all these LLCs for people out of California who didn't want to pay the $600 a year California franchise taxes. Great way to save some taxes, have your income, you know, in no income tax, Nevada. Wonderful idea. And this kept on going on for a long time. Then the California comptroller or the tax division just had this brilliant, light bulb went off. Oh, we should probably look at what Nevada LLCs are listing California addresses and then double check and see if they're actually filed in California as well. They managed to get the penalties, and there were massive penalties. Not only was it the $600 per year for every year that the LLC was established, there was like annual penalties for not filing as well. So, long story short, to everything that Richard's saying and these decisions of whether to file, where to file, and making sure that you're doing things the right way, at the end of the day, can really end up saving you a lot of money.
For sure, for sure. I'm looking in the chat. If you guys have questions, there's a Q&A box and a chat box. You can put your questions in. I got a question that says, when we do can we do a series with a partner? And the answer is absolutely. Yeah, you can have as many partners or members in your LLC as you want. And you can even, I don't really recommend this, but you can even have different members and different managers over each individual series. Because each one is a separate and distinct business. So you can have an entirely different structure within one series versus another versus in the parent. Now, I don't think that's a great idea. And the reason there's a couple reasons. One, your paperwork is going to be a mess. It's going to be a nightmare. And two, it becomes very difficult to figure out how the taxes work. You have one that's a single member, so it should be disregarded, and then go to the, the owner. Well, is the owner the parent LLC or is it this individual? Another may have to be taxed as a partnership. And the easiest thing to do, in my opinion, is set up your parent LLC however you want to handle your taxes. Have the parent LLC be the sole member of each series, and then treat each series as disregarded so that the taxes just flow up and you only have one tax return for that parent series LLC. Or if you're single member, flow up to your personal taxes. and not have to have a different tax return and different regime for each one. The IRS actually came out with proposed rules for taxing series. And they basically mirrored LLCs and said, well, okay, depending on how many members, you can elect to be disregarded, partnerships, C Corp, S Corp, whatever. For some reason, they never actually adopted those rules. They proposed them and then they went nowhere. So there's actually no official rules on how they're taxed. But the presumption from every CPA I've talked to so far is that series are taxed exactly like LLCs, and you just elect how you're going to tax and do it that way. So in that sense, I would never mix and match my members and managers of series versus my parent LLC.
You know, if you don't mind, I'd love to add a few things onto that as well.
Absolutely.
I've actually gone through dealing with different ownership in the different series in a deal a long time ago. And when got started working with the CPA, he says, well, if it doesn't have the same ownership, not disregarded, it has to file its own tax return. So one of the big benefits of filing that one parent company tax return that just takes care of all the series doesn't apply at all. So that really hurts a lot of the benefits there. You also run the risk of now all of a sudden, if you have different ownership in a series, but one of the partners is not a partner of the main parent company, did you just create a general partnership because it's also not registered with the state? Some dicey issues that frankly, just because the series LLCs are so new, the courts just really haven't dealt with these questions.
Yeah, it's only been 20 years since the first series came out. And unlike LLCs, which were widely adopted within 20 years, they haven't caught on quite as quick. So again, only 20 states even have them, and they're all treating things different. Let's see. Someone asks, is a master or parent LLC the same as a series LLC? So the terms get kind of tricky because a series LLC is just an LLC. There's some additional language you put in your formation docs, but otherwise it's just a series that's elected, or an LLC that's elected to have series. We call it a series LLC. And then each cell underneath is a series, which is also singular and plural series, just to make things more confusing. So when I say a master or parent, I'm talking about the whole LLC, and then each little cell I'm going to call a series of the LLC or of the series LLC. And I'm sure that's clear as mud.
I know it really hasn't changed that much. When I started setting up entities, because I was in Nevada, and at that point, everybody had Nevada LLCs. Not anymore because it got really expensive. But we would have a parent LLC being a holding company. And it was before they even had series LLCs. So we had separate LLCs for every asset underneath it. Absolutely drove clients crazy that would have like 40 different LLCs all sitting underneath a parent. The series LLC strategy is exactly like that. I love it. The series LLC really simplifies so much of that. I don't think that it was used very much for the first decade of them lawfully being around. But just, I think it's that year by year, people are getting more accustomed to, well, this is, protected from that asset and the other asset.
Someone asked, can I sell my series?
Of course.
You can. I think we run into those same issues of now we have different ownership of a series versus the parent, and all those things that we discussed might come up. So I don't know if it's a good idea.
If you sold the series, it would be like selling an LLC. There'd be a membership interest transfer.
Mm-hmm.
So
but now you have different members of this series maybe versus another, or versus the parent, and all these issues
then it gets
discussed. And you could sell the assets of a series. And frankly, when I work with individuals that are buying businesses, I almost always encourage them, don't buy the business entity itself, buy the assets of the business, buy the name, buy the logo, buy the customer list, buy the equipment, buy the real estate, but don't buy the LLC itself or the corporation itself or whatever it is. Just leave that behind. And that way you're not buying their liability.
And I love it because so often the seller's like, hey, I'm going to give you this screaming discount if you just buy my LLC versus the assets. And then you have to have that conversation. Well, you don't know what goes along with that discount.
Skeletons are in that closet.
Exactly.
Someone says, if one forms in a different state to do business in California, you still have to pay as foreign LLC and the fees are more. I don't know what the fees are in California, but yeah, if you're transacting business in a state, you have to file as a foreign entity in that state.
And that would include having your office address listed in that state if you're the managing partner.
Let's see.
Can you change profit sharing between the various members in the GP?
Each year.
Each year.
Yeah, you can do. Okay, first of all, I use the term GP. And I know a lot of syndicators and a lot of fund managers use the terms GP and LP. And I think that's just kind of relics of days gone past. You don't ever actually want to be a GP. We don't want that liability. So I presume you mean manager. And we're just using the term GP colloquially. But can you change profit percentage among the members and manage? Absolutely. Change it as often as you want. Now, if you're going to make a decision that negatively affects an owner, you got to have that owner's permission. So if I sign up, for your LLC and I'm supposed to get 80% of the profits, and next year you want to give me 70% of the profits, I better have a say in that. But yeah, the rule, that's the great thing about LLCs. The rule, you can make your own rules as long as you follow them.
And that's why definitely work with a lawyer to do your operating agreements, because there are so many little gotchas and hidden terms sometimes that can just slip on by that if you don't have somebody in your corner, you can miss.
What are typical fees to set up, and can crowdfunding set up in multiple states? I mean, crowdfunding lawyers, I mean us.
I think this is in reference to us.
Okay.
And I don't even know if we do that. You tell you what do we charge for this service? Is it a service that we even provide?
So if someone is doing a securities offering with us, it's just included. We have a flat fee for our syndications. It's based on the amount of money you're raising, and whatever LLCs need to be set up underneath it, we just set them up. It's included in the price. Otherwise, I don't know. What do we charge just for a standalone LLC?
The only time that we actually do it is if it's a wholly owned entity underneath a fund. I love that, and I totally support. We're out here to give education, to help people, and just to help you make the best decisions that you can. But frankly, we're not even selling this stuff.
Fair enough. Now, one thing I'll warn you, and I see this all the time on message boards, Facebook groups, or whatever about business, where someone's like, how much does it cost to set up an LLC? And someone's like, oh, I got it done for $1,500. Oh, I got it done for $1,200, da, da, da. And then someone always jumps in and goes, you idiots, you can just form it with the state. You can form it in Wyoming for $100. That's true. You can form it. You can file the articles of organization or the certificate of formation or whatever it's called in that state, and usually pay a low fee, $100, $300, $500, whatever it is. But you run into that problem I talked about with the asshole manager who didn't get a company agreement, didn't get any operating documents for his entity, and was at the mercy of whatever the state decided to do to govern those entities. And so when you pay a lawyer to create your entity, your LLC, What you're really paying for is them and their guidance in creating the governing documents that are going to set the rules for how that LLC works. That's the value you're getting from an attorney, not the filing's easy. Anyone can do the filing. It's usually one page and a couple blanks. But
doesn't Zoom have an operating agreement for $25?
Right, LegalZoom, yeah. Buyer beware. Buyer beware. You get what you pay for.
Have you ever involved any clients that were sued, had operated through an LLC, and still were found liable?
I haven't, but I'm not a litigator. And that's something that would happen to a litigator who represents a client and they got their LLC pierced. And maybe we should just talk a second about what kinds of things get you pierced.
Let's hear all about your alter ego.
Well, the way you get an LLC pierced is the court decides that your LLC is nothing more than an alter ego. It's just a bank account that you're using. And the easiest way to make that happen is to commingle funds. And so you set up your LLC and you go to the grocery store and you're like, crap, I forgot my card. All I've got is my LLC credit card. Swipe, buy my groceries, swipe, buy my gas. Oh, I need to buy something for my business. So this bank account's a little low. So I'm just going to buy it on Amazon with my personal account. And you start just mixing money together. Well, of course, going to look at that and be like, well, there's no separation between the LLC and you. So the LLC is just a sham and it's just you and you're the one that's liable. A similar one is you don't keep up formalities. Now, the LLCs don't have all the formalities that corporations have, or at least they don't. If you put in your operating documents, we won't have these formalities. We don't require annual meetings. We don't require minutes, whatnot. But whatever formalities you do have, if you don't follow them, if you're supposed to have meetings and you don't have meetings, then they can say, well, this LLC is it's not behaving the way it said it was going to behave. We're not going to allow it to protect you.
I've got kind of a crazy story of I had a client that was held personally liable through piercing the corporate veil. And I thought it was hilarious because his name was John Smith, making it up.
Really?
Of course. So he created the John Smith LLC. And he would get checks that were written to him and he'd just add LLC right on the check and deposit it into the LLC bank account. That was one of the most clear-cut, pierce the corporate veil, alter ego I've ever seen. But he was definitely found liable. They got right through that LLC, and well, he had a personal judgment because of it.
Don't do that.
We did not set up that LLC. That I can tell. Yeah, but always interesting to see what happens to people from time to time.
All right, in the Q&A. If I move to Texas from another state, can I convert my LLC to a foreign LLC? And do I need to have an LLC in my now local state, even if I'm not conducting business in my local state?
So let me answer this one. Because it does come down to what disclosures are required. Entities can generally be the manager of LLCs that specifically in Texas and Nevada and Wyoming, so most states, you can have a trust be the manager of the LLC. And with trusts, they're generally not filed with the state. There's no record of who owns them, controls them. So having a trust being listed can help with the anonymity. If you use another entity like another LLC or another corporation, yeah, you can use it, but eventually you can track up to who really controls that management entity or the manager of that one going all the way up. So the only safe way that I know to keep it anonymous is through trust.
Okay. What about converting? Can I convert my LLC to a foreign LLC?
Why?
If your LLC is registered in a state, it's a domestic LLC in that state. And if you move and you start operating in a new state, you need to file that original LLC as a foreign LLC in the state you're operating in, which basically is like a filing that references back and says, okay, this is a Wyoming LLC that's operating in Texas. So now you're filed in two places. It's one LLC, but you're filed in two places. So nothing really converts, but you are letting Texas know, hey, this Wyoming LLC is here, and it's doing business now. Here's your $700.
Now, if for some reason you wanted to just move the domicile of your LLC from Texas to Wyoming, as an example, generally what we would do is set up a brand new Wyoming entity and buy the assets of the Texas LLC, or it can buy the entire Texas LLC itself, but it actually just ends up looking more like a merger transaction or an LLC purchase to the new resulting Wyoming operating company. And it does not matter where you live. You can form a LLC in not only 50 states, you can also go offshore. There's some great options to organize in the Caribbean. Offers a lot of anonymity, a lot of asset protection. There could potentially be tax benefits, but it's a fine line because you don't want to be in a tax avoidance situation. Tax minimization is absolutely legal. So you can actually form LLCs really all around the world. You just have to deal with the foreign entity filing in whatever states you're doing business in, as well as you may have to get a tax ID here domestically if you're doing business in the United States.
Thanks everyone for attending. Up on the screen is my email address, Nate's email address, our website, and our really awesome phone number that I finally fixed. 469-444-9999. Give us a call if you have any questions. Talk to you guys later.
Thank you so much.